Hello everyone, my name is Mary Irvin and I am a member of the ITA education team. It is my pleasure to welcome you to the first ITA monthly educational webinar of 2023. Thank you for joining us today. Before I introduce the topic in more detail and our panelists, please allow me to do some housekeeping. Firstly, we are delivering this webinar in 5 languages. On your Zoom menu, you should see a button called Interpretation. By clicking on this icon, you can select a channel in your preferred language. I will be presenting the session in English, but you can also listen to the audio in Arabic, French, Russian, or Spanish. Today's webinar is part of our educational monthly series that are publicly available and designed to tackle key anti-doping topics and to raise clean sport awareness. As for all of our sessions, it goes without saying that we encourage debate, interaction and questions, but we do not tolerate any kind of aggressive behaviour or abusive or racist language. We trust you will all join us in the spirit of fairness, respect and integrity. Some other housekeeping points. Please do use the chat or the Q&A function. You can use the chat function, for example, to tell us the sport you are representing. The Q&A function, please use this to ask a question on today's topic of our expert panelists. We'll leave some time at the end of the session to address those. Finally, note that we record all our webinars so we can make them available on our website and YouTube channel for those who are not available to attend the live session. As always, it is my pleasure to give a shout out to our official presenting partner, Informed Sport. Their investment allows us to deliver the webinar programme free of charge in 5 different languages. Informed Sport is a global certification programme for supplements that batch test products for substances prohibited in sport. As supplement contamination continues to be one of the leading causes of inadvertent doping, we encourage athletes and athlete support personnel to check all products before use at sport.wetestyoutrust.com. Also, the ITA is proud to be recognised by UNESCO as a leading international organisation for the delivery of anti-doping programmes. And this educational webinar is delivered with the support of the UNESCO International Convention Against Doping in Sport. So on to today's topic, anti-doping rule violations and the right to fair hearings. Over the next hour, we will take a look at hearing panels with a particular focus on the anti-doping and appeal divisions of the Court of Arbitration for Sport, or CAS for short. What we want to do today is to demystify the process for athletes, break down the legal process by presenting the most important and practical information for you to know, such as what is the decision-making process, who testifies and what evidence is presented, who is the judge or arbitrator, what is the appeals process, and the first thing that we will look at is what happens before a case is heard by a hearing panel. Answering all these questions and more are today's 2 expert panelists who will share their expertise and advice. So on that note, I would like to invite Fabien and Damien to turn on their cameras and offer them a warm welcome. Firstly, I would like to introduce Fabien Cagneux. Fabien is the Managing Counsel for the Court of Arbitration for Sport for Anti-Doping Division, or CAS ADD for short. Fabien has worked at CAS since 2012, aside from an 18-month spell as an attorney at law for Libra Law. Prior to CAS, Fabien worked at various law firms in Geneva, Switzerland. He started his law career in the world of sport, working in the legal department of UEFA. He has law degrees from the University of Geneva and the Humboldt University in Berlin. Welcome to today's webinar, Fabien.
Hello, everyone. Good afternoon and good morning to all of you.
More from you in just a few moments' time. Next, I would like to introduce Damien Clivaz. Damien is my colleague at the ITA, where he holds the position of Senior Legal Counsel. Damien has been a lawyer for 6 years, and prior to joining the ITA in 2020, Damien practiced arbitration and sports arbitration in a number of law firms, both in Switzerland and in the UK, notably defending athletes accused of anti-doping rule violations. He has legal qualifications from the University of Freiburg and the University of Geneva. Welcome to you as well, Damien.
Hi, Mary. Hello, everyone. Happy to be here.
So as mentioned earlier, we're going to leave some time at the end of the session for questions from you. So if you'd like to ask our panelists anything related to today's topic, please do pop them in the Q&A box. Now, during the webinar, you're also going to see a couple of poll questions. Please do take part in those. Your answers are completely anonymous. And on that note, I would now like to hand over to Damien, who's going to get us started on today's topic by looking at the pre-hearing panel process. Over to you, Damien.
Many thanks, Mary, for the kind introduction. And as Mary just mentioned, before we get to the anti-doping hearing panels, which will be our main focus today, I suggest to take a few steps back and to quickly go over the procedure that actually takes place before cases are referred and find their way before a hearing panel. And we'll particularly take a look at the main rights and options which are available to athletes and or other persons who are charged with potential anti-doping rule violations, or as I will often refer to them today, ADRVs for short. Now, again, this will not be the main focus of today's webinar, and for more information on the legal framework and on the results management of anti-doping rule violations, I suggest our excellent May 2021 ITA monthly webinar, which was titled The Legal Side of Anti-Doping, and where my colleague, Ms. Dominique Leroux-Lacroix, our head of legal here at the ITA, gave a very detailed presentation on the legal framework applicable to anti-doping rule violations. And you'll find a freely available recording of this webinar on YouTube. And I hope we're able to post a quick link to this webinar in the chat right now. And so let's dive straight into it. How does a case end up before a hearing panel? Well, the first necessary step is, of course, an alleged anti-doping rule violation, an alleged ADRV. And as you can see on this slide, the 2021 WADA code lists 11 types of potential anti-doping rule violations, ranging from the presence of a prohibited substance in an athlete sample, that is, of course, the most common one. We also have, for example, evading sample collection or trafficking a prohibited substance or method, and all the way to sanctioning the act of threatening or intimidating someone into not reporting information related to an alleged anti-doping rule violation. So as you can see on this slide, some of these anti-doping rule violations are applicable to athletes only, such as, for example, the presence of a prohibited substance, but others can also be committed by other members of the sporting community subject to the anti-doping rules, for example, athlete support personnel, coaches, or officials. I'd like now to turn to the key milestones of an anti-doping case. And here on this slide, you have a summary of the process which takes place from notification all the way up to the appeal. Now, I will go over the first two steps here and also touch upon the various different options that are available to resolve a case, even before it gets to the hearing panel stage. And let's start with the notification. Now, before notifying an athlete, the anti-doping organization may learn of an alleged anti-doping rule violation through various different means. For example, it could be a laboratory informing us that a sample has returned what we call an adverse analytical finding, but in other words, means that a sample contains a prohibited substance. Or for example, if a doping control officer reports to us that, that an athlete has refused to provide a sample or evaded sample collection, or if our intelligence and investigation team obtains information, for example, that an athlete is trafficking a prohibited substance. And I'll give a final example. We could also get a report claiming that a coach is administering, for example, prohibited substances to his athletes. Now, after an initial review of the case file, the athlete or the other person involved will be notified of this potential ADRV by the anti-doping organization. And concretely, what does this mean? This means that the athlete will receive an email, either directly to his email address if it's available, or via his or her national federation. And so that athlete or person will receive an email attaching a legal document which contains all of the relevant information in relation to the alleged ADRV. And this notice will most importantly contain information as to the right to request the analysis of the B sample and or to attend or be represented at the opening of the B sample in the laboratory. It will also contain information in relation to the provisional suspension. So that is whether one is imposed, or about the right for the athlete to accept a voluntary provisional suspension, which will allow the athlete to immediately start serving a suspension. That time will then be credited, of course, against the final sanction, which may ultimately be imposed. And so this initial notice is very important, in particular for the two reasons I've just mentioned, so B sample and provisional suspension, but it will also contain information in relation, of course, to the alleged anti-doping rule violation, the potential applicable sanction, and of course, the right for the athletes to provide explanations, and finally, information as to the next procedural steps. And so, as I've just mentioned, every athlete or other person charged with against which an anti-doping rule violation is asserted will be immediately provided with the opportunity to provide explanations and, of course, documents to the anti-doping organization. And so these explanations can be quite varied depending on the case. But for example, they can range from explanations related to how or why a prohibited substance was detected in an athlete sample, or for example, explanation as to why the athlete failed to submit to sample collection. And here it's quite important to remind everyone that it's the athlete's burden of proof to establish the facts in his or her explanations on a balance of probability. That's the standard of the burden of proof. And for those wondering, and rightfully so, what the term burden of proof means, simply put, it means that where the athlete or person wants to establish a fact in their explanation, such, for example, as the fact that the athlete was taking a particular medication, it's for the athlete to establish this fact by providing supporting documents or statements as proof thereof, and he or she therefore bears the burden of proving his or her allegation. And very concretely, it is not enough, for example, to say, okay, this medication was prescribed by my doctor. It's the athlete's burden to actually provide documents, to provide statements which establish this fact. So for example, a copy of the doctor's prescription or a pharmacy receipt or a statement, for example, provided by the doctor. And so at this stage, after receiving the explanations from the athlete or person, the anti-doping organization will assess the explanation. It will assess also the documents that were provided, and it will determine firstly whether an anti-doping rule violation has indeed been committed or not. And in the affirmative, it will also determine the applicable sanction and propose sanctioning terms. In other words, the anti-doping organization will propose an applicable sanction to the athlete. And then the athlete or person is free to either accept the proposed consequences, the proposed sanction, and therefore waive his a right to a hearing. And the case is then resolved via a decision of the anti-doping organization. And in this case, if there's a waiver of the right to a hearing, it's important to note that the decision can be appealed by the World Anti-Doping Agency and by the National Anti-Doping Organization. and that is Article 8.3.1 of the WADA Code. Now, the second scenario, of course, is that the athlete or person can also disagree with the proposed consequences and can request that the case be referred to what we call the first instance panel, which will keep us busy today, and more of that in just a moment. But although today's topic is about hearings, I think it's also important to note that there are other options in addition to that, to the one I've just mentioned, to resolve a case without going to a hearing panel. And those are often actually in the athlete's best interest. And so I suggest that we quickly take a look at those now. I first suggest we take a look at the regime of substantial assistance. That's Article 10.7.1 of the WADA Code. And this is when an athlete or person against whom an ADRV is asserted provides new information leading to the discovery or the bringing forward of another anti-doping rule violation, of a criminal or a disciplinary offense, or of a non-compliance from a signatory or a laboratory. And in this case, there's the possibility of a without prejudice collaboration agreement between the anti-doping organization and the athlete, which can include the suspension of part of the consequences of the underlying ADRV. Another possibility is the result management agreement, that is Article 10.8.1. So while this only applies for bans that are 4 years or more, it's a very important provision which allows athletes when they or support personnel when they immediately admit to the ADRV and to the consequences proposed by the anti-doping organization. It gives the possibility of a 1-year reduction of the period of ineligibility. Here, it's quite important to note that it has to be done within 20 days of being charged with the anti-doping rule violation, and that it excludes any other reduction in sanction. Now, this option very concretely is most often applicable to cases which involved non-specified substances, and it's really often in the athlete's best interest to benefit from this provision. And this possibility, as I've just mentioned, is time limited and is not available to athletes once the case is referred to a hearing panel. So this is really an option to consider. And the final option that you see on the slide here, Article 10.8.2, is referred to as the case resolution agreement. And this is applicable where the athlete admits to the violation, agrees together with the anti-doping organization and the World Anti-Doping Agency on the applicable consequences. And in this case, the period of ineligibility, the suspension, can be backdated, so can start up to the date of the sample collection. And it can also be reduced depending on the athlete's degree of fault. However, and here it's also important to note that at least half of the agreed upon period of ineligibility must be served. And in this case, also a particularity, the agreement is final and cannot be appealed. So maybe to summarize this introduction, we've now seen that there are in fact several options which may lead to a case being resolved without the need for it to be referred to a first instance hearing panel.
Thanks so much, Damien, for setting the scene on the different routes and the way cases can be resolved before they even get to a hearing panel stage. Now, before we welcome Fabien back further, the audience has heard a lot from us already today, so maybe it's time to get a little bit interactive, and maybe we could ask the audience a question. So in just a moment, you are going to see a poll question appearing on your screen. There it is now. And I am interested in what you think the answer to this question is. Let me read out the question for the purpose of simultaneous translation. And that is, what percentage of cases are resolved before being referred to a hearing panel? And you can choose from 20%, 40%, 50%, or even 80%. Now, as I mentioned earlier, single choice answer here, and all the answers are anonymous, so please do give it a go. Damien, here I can see we've already got pretty good participation. We've got over 50% of people who have given it a go. While we wait for a few more answers to come through, I do just want to say hello to all the different sports we have represented. Apologies in case I've missed anyone, but I can see here that we have fin swimming, we have wrestling, sambo, ski mountaineering, dance sports, taekwondo, fencing, and I also believe we have people from all continents represented in this webinar today. So thank you again for joining us. Okay, that's pretty much 3/4 of people who have answered, Damien. So let's close the chat here and see what the most popular answer is. So it's pretty close. As we can see here, we have 80%. The 29% of people think that 80% of cases are resolved before a hearing panel, but equally 29% of people think that 40% of cases are resolved before going to a hearing panel stage. And just behind that at 26% is people think 50% of cases are resolved. So Damien, perhaps you could enlighten us all. What is the correct answer here?
Very interesting results here with a tie at 40 and 80%. And maybe just a caveat before I give the answer. This is, of course, based to, it's not an absolute answer. It's based on our caseload today. So cases managed by the ITA. And it's actually 80% of cases that are resolved without the need or before being referred to a hearing panel. So actually 80% of cases never end up before a hearing panel.
Thanks for that, Damien. So I think, as we can see from the statistics, that that answer will come as a surprise to quite a lot of people listening today. So it's really helpful that you've gone through the processes in place before we would even get to this stage. But let's take it to the next step. And to summarize your section, Damien, there are some important rights regarding the right to a hearing that will be important for athletes to know about. Could you maybe quickly summarize what that is?
Absolutely, and I think to tie in with our subject today, the most important right maybe to keep in mind, and which will be the main focus of our session today, is the right to a fair hearing for every athlete or person who is asserted to have committed an anti-doping rule violation. And so this right is enshrined, as you can see on this slide, in Article 8 of the WADA Code, and it's implemented in your respective international federation anti-doping rules. And now this right can be implemented differently depending on the international federation, with certain federations resorting to their own internal first instance panels, and certain federations delegating their first instance decision making power to third parties, for example, to the CAS Anti-Doping Division. And this makes a perfect segue into the next chapter of today's webinar and our distinguished guest today.
Thanks so much again, Damien. We'll see you a little bit later for the discussion and then the live Q&A section. So as Damien mentioned there, what better way than to welcome back Fabien, who is going to be explaining what happens when cases are referred to a hearing panel. Thanks again for joining us, Fabien.
Thanks, Mary, and thanks to Damien also for the very detailed and meaningful presentation.
Great. So on this slide here, we've just popped up what the program for your section today is going to be. So our audience can see that on this slide, we're going to be discussing various things from how cases end up at CAS through either first or appeal hearing panels. But we're also going to get really practical as well about what happens during a panel. And you're going to discuss things like hearing evidence, to the selection of arbitrators, to the languages spoken, and also to things like legal aid. But before I go off camera, perhaps as we've just done a poll question, we should do another one to kind of set the scene and introduce your section. So again, everyone should see a question appearing on their screens. As before, it is single answer and answers are anonymous. And the question is, how many CASs were filed with the CAS ADD in 2022? And just 3 choices this time. You can choose from 15, 30, or 50. So I can see the answers coming through pretty quickly. Thank you for participating. We're already up at almost over 60% now. We'll just wait a couple more seconds. You can see that the middle answer, 30, with 48% is already the most popular. Okay, I think we can shut the poll now and have a look at the answers. So we have a clear favorite with this one, Fabien. Perhaps you could let our audience know, is the most popular answer the correct one?
No, the correct answer for 2022 was 15. I must say it was a quiet year for the ADD. 30 cases would have been correct. For 2021. We registered 29 cases. So the ADD is still a young first instance. We have been implemented in full time as of 2019. So and then COVID struck all the sports competitions. So we still do not have a lot of cases, but it's increasing more and more. So 15 is the correct answer for this one.
Okay, lovely. Thanks so much for that. So a lot of people who chose 30, they'd have been right, but just 12 months previous. So I think overall, the audience were pretty knowledgeable with that question.
Yeah.
So I will switch off my camera in just a moment now and hand over to you, Fabien, for your presentation. Thanks again.
Thank you very much. So first, I have to explain that we have at the CAS, it's the Supreme Court for Sports Resolution. We are based in Lausanne, Switzerland, and almost 45 people are working at the CAS Court office, and we have on our list of arbitrators more or less 400 arbitrators from all around the world, from 80 to 90 different countries. The prerequisite to be a CAS arbitrator is to have a law degree. Most of them are lawyers, professor of law, or judges, and of course to have knowledge in sports law and arbitration. So first, you have for anti-doping rule violations, so I'll call them ADRV, you have 2 different ways to go to the CAS. You have the first hearing panel, the CAS Anti-Doping Division, so I will call it the CAS ADD, or the appeal hearing panel, which I will call the CAS AAD. So just be careful about the difference of the both instances. So in which way do you have to go to the CAS? You have to find it. You have to find it first in the ADRV. Can you just come back to the previous slide? Thank you. So if you go to the CAS ADD, I took this picture completely randomly on Google. So these athletes didn't come to the ADD, by the way, but it's just a matter of example. So if you are a swimmer or a weightlifter or a skeleton athlete or a biathlete, this federation have delegated the adjudication of first hearing instance ADRV to the CAS ADD. So you should be aware of that. And this is only an example of a federation. We have more or less 25 federations which delegated to the CAS ADD. How does it work to the CAS ADD? So as Damien mentioned, you have first the result management process initiated by the responsible international federation. I will call it IF. And then, as Damien also mentioned, is there an agreement on a sanction? So as he said, in 80% of the cases, yes, it doesn't go to the CAS ADD, so it stops at this stage. If not, if there is no agreement on the sanction, the case will be brought before the CAS ADD. So how does it work concretely? The federation, acting as the claimant, will file a request for arbitration and request the CAS ADD to start proceedings against the athlete. There will be an exchange of written submissions, so there will be a statement of a request for arbitration. Then the athlete will be allowed to file an answer and to provide evidence. Of course, I will come back to that in a few minutes. A hearing is also proposed by the arbitrator, and then a decision is made, is notified to the parties, meaning the IF and the athletes, with then possible appeal with the CAS Appeals Arbitration Division, so the CAS AAD. Then this is the other way to the CAS. If the International Federation did not delegate the first instance and adjudication to the CAS ADD, you go directly to the Appeals Division. So here you have some example. It is also completely random random pictures I took on the internet. So if you are an ice hockey player or a volleyball player, basketball or ice skater, you have also one of the biggest federation did not delegate the first instance adjudication by the ADD to the ADD, like World Athletics or the ITF for tennis, FIFA for football, UCI for cycling. This does not go to the CAS ADD, but directly to the CAS Appeals Arbitration Division. So how does it work? It's almost the same. So result management process is also initiated and managed by the responsible IF. A decision will be then rendered by an international adjudicatory body of the IF. It could be the disciplinary commission or the arbitral tribunal of the IF. There are different names given by the International Federation. And then there is a way of appeal to the CAS. So here, this is a filing. It starts with the filing of a statement of appeal, this time by the athlete. So this is a big difference between the two instances. If you go to the CAS ADD as a first instance, the federation is the claimant and is bringing a case. But for other cases where the IF did not delegate the first instance adjudication to the ADD, it goes directly. So it goes to the appeals division, and then it is the athlete who is filing a statement of appeal. There will be, of course, an exchange of written submissions, starting then with the athlete. Then the federation will also file an answer. The panel of arbitrators will hold a hearing if the parties request it, and then there will be a decision. There is still a possibility to appeal this decision to the Swiss Federal Tribunal, who is also based in Lausanne, and which is the only instance to review arbitral award rendered by CAS. And this is also the appeal will be only admissible on very limited grounds. So let's, after making the difference between the two instances, let's switch to some practical information for athletes and also for lawyers who are coming before the CAS. So there will be first written proceedings, which will start with the filing of request for arbitration in case of ADD, or a statement of appeal and an appeal brief for the appeal cases. Statement of appeal is very short. It should only contain a few prerequisites to be admissible, and then it's completed it's completed by the filing of an appeal brief, which is the main submission in appeals cases. Then there will be an answer, and if necessary, we could have also a second round of submissions. It's not always, it should be requested, it's not automatic. It mostly depends on exceptional circumstances, but we can have a reply and then a rejoinder. So basically, the written submission must contain the factual background, so the explanation of the dispute between the parties, and then of course the legal grounds and also the prayer for relief. So what the athlete or the IF is seeking for. For example, in a CAS ADD case, the IF will request the suspension of the athlete, the disqualification of results, etc., etc. And to the contrary, the athletes in an appeal cases will mostly request the annulment of the decision, or maybe the reduction of the sanction. It is very also important to address a list of exhibits with all documents which will support the brief, including any witness statements and also expert reports, if any. Other practical information for CAS procedure, which is very important, so the taking of evidence. As Damien says before, the athletes needs, if the athlete may make appeals or challenge the commission of an ADRV, he needs to file evidence. So documents in writing are very important. It could be, as he says, prescription from a doctor or receipt or anything like this. You can also rely on witnesses. It could be a coach, a teammate, the doctor, or someone who is capable to testify on the facts. Be aware that we are in arbitration, so most of the time the panel will rely on witness statements or a written declaration of the witness, which will be the scope of his testimony, or at least a brief summary of what he or she will say during the hearing. You can also file expert reports, which are very common in doping cases. They are mostly issued by doctors or biologists or experts in pharmacology, or all in this scientific topic. You can also, of course, file audio or video footage, and also the athlete is always invited during the hearing to give his or her personal statement. Now turning to the arbitrators. So as I said, the arbitrator's role is to rule on the case in front of them. So as I said, they have the role of a judge, if you like so. And as I said, they have all law degrees, being lawyer, judge, or professor. They are not working 100% for the CAS, so they have their own activities aside, and they are nominated to rule on cases. So we have different way to nominate an arbitrator. If you are in a case before the CAS ADD, the sole arbitrator, it could be a sole arbitrator which should be nominated by both parties, or in case of failure by the president of the ADD. So we have the appeal division and the Anti-Doping Division has both a president and a deputy in order to rule and to take decision when arbitrators are not nominated for the moment. If you have a 3-member panel, each party will be invited to select an arbitrator, and then the president of this panel shall also be jointly designated by the parties, or if they don't agree, it will also be the president of the ADD to nominate such president. If the case is pending before the CAS Appeals Arbitration Division, it works slightly differently. The sole arbitrator is appointed directly by the president of the Appeals Arbitration Division, or if it's a 3-member panel, the athlete and the IF, so each party will then select its own arbitrator, and the president of the panel will be nominated by the president of the Appeals Arbitration Division. Now, languages, it's interesting and quite important aspect of the case. So we have now 3 official languages, which are English, French, and Spanish. So it means that all submissions, all documents must be translated in these languages. So any documents which are not translated in one of these languages will not be admitted to the file. If it's not translated at the beginning, the panel may ask translation at a later stage, but if a party relying on such document, which is not then translated, will not be admitted to the file at the end. We have possibility to have bilingual proceedings, meaning that we would not need translation, but it should only be upon the agreement by the parties and also the panel and the CAS Court office. In most of time, it's English, Spanish, and English and French. For example, we have many cases, we have some cases, I must say, where the submission are drafted in English, but the parties are Spanish or French speaking, and they have documents either in Spanish and French, and all parties understand the documents, but to avoid cost of interpretation or translation, they agree to have not to translate them and then to have a bilingual proceedings. It is also possible to have a procedure in another language, also with the consent of the parties, the panel, and the CAS Court office. So mostly it's proceedings in German and Italian. So hearing, how does it work actually? So you have always an introduction by the panel, housekeeping matters, so organization of the hearing, with order of testimony of the witnesses, etc. How will be the course of the hearing, and also dealing with preliminary issues. For example, issues of translation of documents or admissibility of some witnesses which were not announced, etc. This is the first part, and then you have the parties' opening statement. It should be very short and concise. So it's only, I like to call them like a movie trailer. It should be a few minutes just presenting the case, the key issues, but not pleading the case, because the lawyer will have time to develop all his legal argumentation at the end. Then there is the examination of the witnesses and the experts, also being available for cross-examination by the counterparty. And then, as I said, the closing statements, where the parties will plead their case with the possibility to respond to the arguments of the other and to challenge these arguments, etc. And then rebuttals, so reply if necessary. Hearing. So is it mandatory to have a hearing? It's a right to have a hearing, as Damien said before. An athlete will always have the right to have a hearing and to be heard before the CAS. Is it mandatory? No, actually, it's not mandatory. If the parties waive their right to a hearing, the panel will rule on the case only on the basis of the written submission and documents provided by the parties. I must say that this mostly concerns the contractual cases, but in anti-doping cases, it is really rare that a party does not request a hearing. Is it private or public? I will leave this topic a little bit later, which will be discussed with Damien during the roundtable, but most of them are private, but we may have public hearings on several conditions. Are the hearings in person or virtual? I must say the general rule before COVID was in person, with the possibility to hear some witnesses or experts by video conference. But now with the COVID, I must say that we have a lot of online hearing. Although the situation after COVID is somewhat now more relaxing, parties ask more and more to be heard by video conference, which also reduce the costs and expenses of travel, accommodation to come to Switzerland. Be careful of the language. Also, if you need an interpreter, keep in mind that we have only 3 working languages. So if an athlete does not feel really fluent in one of the language, he or she should hire an interpreter. This is my personal tips for counsel. Also, if one of the counsel is not fluent in the language of the procedure, it should be better to be assisted by a co-counsel fluent in English, Spanish, or French, rather than to have an interpreter. Also for the fluency of the pleadings. I think we come almost to the end. So also some information about urgency cases or proceedings. We have the possibility to have expedited proceedings, which are applicable both to appeal and anti-doping, in the first hearing panel. This is Article R52 of the Code and Article A19.9 of the ADD rules. So the idea is to have a really tailored procedure for the parties, because the reason is that, as you will see in the picture, you have the picture of Franck Ribéry or Michel Platini. Sometimes you have a competition coming up. That was the case for Franck Ribéry during the Champions League like 10 or 11 years ago. He received the red card in the semi-final and he was suspended for 3 games. So he wanted absolutely to play the final. And the game was 2 weeks after. So we had the possibility, with the consent of all the parties, to have a very fast-track procedure, of course, with complying with the right to be heard of all the parties. So the parties will be able to file written submission, to have a hearing and to have a decision before the competition starts. This is also possible, as I said, before the CAS ADD. And it's also, the other example is during election, if you have an election coming up and that candidates is prevented to, is suspended, is prevented to take part to the election, it is possible to have an expedited proceedings. So instead of having a 6 or 7 months procedure, it's squeezed in like 2-3 weeks or 1 month. The other way also, in case of emergency, you have the possibility to file provisional measures. Also, if an athlete is suspended and he wants or she wants to take part in a competition coming up in a few weeks, you can apply for the stay of the decision suspending the athlete. So it's not automatic. So you have the athlete must ask for them when filing the appeal. It's also possible to file the provisional measures request before the appeal for really urgent cases. So here, normally at this stage, as it is very early in the procedure, we don't have the president of we don't have any panel constituted. So the president of the CAS division decides on the request, but the dilemma sometimes is, should we wait for the constitution of the tribunal? The requirements that are cumulative. It's the athlete must prove the risk of irreparable harm, likelihood of success on the merits of the appeal, and the balance of interest. And final information, CAS has a fund for legal aid for athletes in the precarious financial situation. They may apply for legal aid, which we cover the cost of arbitration, also expenses in connection with CAS hearings for travel, accommodation, etc. And also we have a list of pro bono lawyers, which is held by the CAS. But we are 31 January, but we have actually new legal aid guidelines applicable as of tomorrow. I think they are already online on the CAS website.
Thanks so much, Fabien, for all these practical tips that you've given us over the last 20 minutes or so. It's once again, it's fabulous to have you here. I'd also like to welcome back Damien at this point as well. Now, we do have a roundtable discussion planned here, but I can see that already we're getting quite a few questions coming through, and I'd really like to be able to have some time to address audience questions. So maybe we have 3 discussion points. Maybe if I can come to each of you just to do a very quick summary of what's on the slides here, the most important points in 30 seconds. Our audience will all receive these slides after the webinar ends as well, so they will be able to refer to more information there. So let's go to the right to a public hearing. Damien, maybe you can give us 30 seconds headlines on this one.
Absolutely. So right to a public hearing, in short, yes. The European Court on Human Rights has confirmed this in the Mutu-Pechstein decision and the Landmark decision. It's implemented both at the CAS ADD and at the appeals division levels, and it can be requested by a physical person party to the proceeding, so not by an anti-doping organization. And final point, it can be curtailed or restricted for morality reason, public order, national security, or in the presence, for example, of minor athletes. And you can also imagine the case of the fans of an athlete storming CAS right before a hearing. So those are instances where that right can be curtailed. But in short, yes, the right to a public hearing is guaranteed and implemented in the CAS ADD and in the CAS Appeals Division rules in the CAS code.
Thanks, Damien. And over to you as well, Fabien. Same rules.
Yeah, look, actually, I think Damien has covered the topic. I must say that since the rule is in force, we only had 1 or 2 hearings public. So the famous was Sun Yang. He requested a public hearing. So we only had this request, which was held in a hotel and also streamlined, so it was available online. We don't have so many requests because doping can also affect privacy and intimacy of the athletes, and many athletes does not want to expand their life to public, to journalists. So this is one, I think, of the reason why they don't ask so many public hearings.
Thanks very much. And maybe we stay with you for this one as well. The right to legal aid, you did mention a little bit earlier in your presentation. Any quick things to add to this one?
So yeah, we have a fund for legal aid for athletes which do not have the financial means to come to CAS to pay the advance of costs, which cover the arbitrator's fees and the administrative costs of CAS. There is a form to fill in with to give with supportive documents to show and to show the financial situation of the athletes. Yeah, we do. We also have this pro bono list of this pro bono counsel list. So I must say that before the ADD, there is no need to fine for legal aid because the athlete will not be charged for any costs before the CAS ADD. It will be the cost system is not affecting the athlete. The only expenses he or she may have is to cover his legal expenses for his lawyers. And then there is still the possibility to apply for for a pro bono lawyer.
Thank you. And then maybe if you switch to the next slide, I won't ask you both to address this one so that we can get to the live Q&A, but everyone is going to receive these slides just after the webinar ends, and that will give you more details about the expedited proceedings before a major event. You're also going to get a link to a lot of resources, some of the things that we've talked about today and other additional information. So you'll be able to click on those links and read more about the topic shortly. So let's spend the last few minutes having a look at our live questions. The first one here, maybe I can ask Damien to address this one. The question, does an individual accused of an ADRV have the right to request the CAS ADD hold the first instant hearing rather than the International Federation?
Good technical question. The answer is no, because the CAS ADD draws its competence from the arbitration agreement included in the anti-doping rule of the WADA code signatory. So the basic rule is no. However, it wouldn't be a proper answer from a lawyer if there was no exception, and that exception is an agreement of all parties involved. That's mentioned expressly at Article A2 of the ADD rules. There is the possibility for an ad hoc agreement from all parties involved in the dispute to submit the dispute to CAS instead of the IF panel. But the general rule, and that to keep in mind, is no. There's no right for the case to be referred to the ADD instead of the International Federation panel.
Thanks so much. And then maybe Fabien, you can do a quick answer for us on the next two. Maybe we take them together. Can you explain when a CAS hearing is heard by a sole arbitrator versus a three-person panel? And then a follow-up one, what percentage of CAS cases are related to doping?
I will start with the second one, which is a bit the easiest for me. I'm not holding any statistics at CAS, but as I heard, it's keeping us busy at 20-25%. I must say 20% of cases are doping cases. It decreases a little bit for a few years. So yeah, normally it's 20-25% of doping cases. Now the first question, why sole arbitrator or a three-member panel? It really depends. It could be a request. It could be a request from the appellant. Also, he can ask to be heard by a sole arbitrator, or he can ask. He or she can ask for a three-member panel. Most of person thinks that a three-member panel, we have 3 persons, so there will be a better decision than rendered by one, which I think it's not true, because we have a very good arbitrators which can work very well alone by their own. It's also a sole arbitrator would also be a quicker than a 3-member panel, especially if you have a hearing, because with the sole arbitrator, you only need one person to travel, but three-member panel, you have 3 persons. And as I said, they are not working 100% for CAS, so they have also busy diaries, so you have to have them travel to Lausanne. And it's also a matter of costs. Sole arbitrator will be less expensive than a 3-member panel. So it really depends on the circumstances.
Thanks very much. And maybe we squeeze in the final one as well, which is, do ADD rules also apply on the AAD rules? Fabien, maybe I can come to you for this one as well.
Yeah, no, this is a completely 2 different set of rules. The ADD rules are very specific to the first instance body of the CAS ADD, and the AAD rules, the Code of Sports Related Arbitration, is specifically designed for the appeals procedure. If they are available on the CAS website, both, and you will see that there are differences. The procedure, I mean, the proceedings works are quite the same, but there are some differences, and you cannot apply one to another procedure.
Thanks so much. That was the final question just answered there. But if you would like to ask us any other questions, please do reach out to us at education@ita.sport. So that wraps up today's webinar. There's really just time for me to say a big thank you to our panelists, Fabien and Damien, and to you, our audience, for joining us. After the webinar ends, as well as the presentation, you will also receive a link to a short survey. We'd be really grateful if you could take a couple of minutes to fill that in for us. And if you enjoyed this webinar, please do join us for the next one on the 22nd of February. Registration information will be open in due course. And finally, if you would like to receive additional updates from the ITA, please sign up using the link that you find on the slide. So thank you all once again, and I wish you all a very good day.